Good morning, my name's David Rosen. I'm partner and head of litigation at Darlington's Solicitors LLP. I am also a professor of law, an associate professor at Brunel Law School in Brunel University, and I lecture, amongst other things, in civil and criminal fraud, but as a practicing lawyer I practice in all higher courts, both in criminal and civil law. Today I'm going to talk to you about adversarial advocacy. This is something which is as much necessary to know about as a lawyer and an advocate as it is about a litigant in person, and this lecture or this talk is given to you to assist you as a litigant in person. So advocacy is a skill. It's like riding a bike, like riding a bicycle, and of course lawyers and law students have an opportunity to learn their mistakes when they're in law school, and you don't get that chance. So what I would suggest before you do anything is go off to court, sit in a public gallery and watch what happens. Watch where everyone sits, watch what annoys the judge, what pleases the judge, and start taking notes. Take notes on body language, take notes on the tone, and that will be your bicycle. That will be the way you start to learn. You'll also see when you go to a court that it's set out in a specific way. The judge generally will sit slightly above everyone else, and he will be looking down. He or she will be looking down, and that judge will see everything in the room, everything completely. A body language, a slightest eyebrows up in the air, an annoyance, a fidgeting, an irritation, who you're talking to, what annoys you. They will see everything and they note everything. You will sit on one side of the court facing the judge, and your opponent will be on the other side. There may be press in the court, there may be public. It normally sits in the back of the court. Sometimes in front of the judge sits a clerk or an associate to the judge. They normally mind their own business and they're sitting there recording. Most things are recorded, and you can get transcripts of court cases. And don't lose your temper. Very important. This is adversarial advocacy. But the second you lose your temper, as in any argument, the person who's listening to the argument will generally consider you the bad one. Even though you're trying to be passionate and sincere, it may not come across as that. Remember, as a litigant in person, you are subjective. This is your heart and soul. You've lived and breathed this case, and it's very personal to you. Whereas for an advocate, you're more objective. You can stand back, you can be almost philosophical about the situation. But this is a polite contest, passive-aggressive, a polite contest. And you should remember that, it's a polite contest. So shouting and screaming is a no-no. Now, the psychology, I suppose, if I was going to tell you about anything, what you need to be is irresistible. That's what you need to be. Irresistibility is what you're trying to achieve. You're there to assist the court, you're there to help the court along, to find their way, or at best to lead the judge down the garden path that gets to the house, which has your answer in it rather than the other person's answer. So you're there to be assisting, but obviously to be an irresistible argument, that the judge can only follow your argument rather than the other person's argument. You don't irritate the judge. Never irritate the judge. Be persuasive. But I would suggest this. You talk to a judge as if they're an elderly grandparent. You treat them with respect. You don't shout at them. Perhaps you should talk to them as if they are slightly deaf or slightly hard of hearing. And I don't say that because judges are stupid. They're anything but stupid. But remember this. They are trying to take in all the information, and you have all that information, and your job is to educate that judge and to assist them with the issues to hand and get them to make a decision, hopefully in your favour. So even if the judge has read the papers, they won't know the case as well as you are, as well as you do. And you have to speak slowly and properly and clearly. How to dress. It's very important how you dress. Don't wear big jewellery. Don't have lots of makeup on. Don't walk in with very loud or garish shirts or suits. It doesn't impress and it seeks to annoy. The judge is there to hear you and what you have to say, and nothing should detract from your case. Nothing should detract from what you're saying. So that's why, on the whole, in most advocacy codes of dress, and there is a code of dress for advocates, it's normally a dark blue or a dark black or dark grey suit, and either a plain blue or a plain white shirt. Again, you're there to assist the court and for the court to hear what you have to say and not how you dress and what you look like. On the other hand, don't dress scruffily, because that will also stand out. Be smart. Have polished shoes. Make sure that the creases are there in the shirts in the right places. Whilst this is the smallest of detail that I'm talking about, it matters. It does matter. People of importance at court. It's very important to know that the judge isn't just the main person that you have to impress. The court staff are also people that you need to keep in line and on your side, so to speak. Also, the court usher and the clerk to the judge. So you treat them the same way as you would as the judge. And remember the grandparent who's hard of hearing. Talk politely, be polite, and you go a long way. You start to be rude, the court starts to not do favours for you. It starts to go into you'll fall into the line of the paperwork and the bureaucracy. You'll see pasted all over the court that if you're abusive in any way to court staff, that they won't tolerate it. You don't want to be in satellite litigation. Just they're there as a means to an end, and everyone's there to assist the court and to make the case run smoothly. Poise. Poise is very important. How you hold yourself. We don't want any divas. No divas. No swagger. Don't walk in that you own the place. On the other hand, you have to have an element of swagger, and you have to have an element of self-importance, because you're there to tell the story. You don't want to be telling the story as a mouse. On the other hand, you don't want to be telling it as a roaring lion. Be more of a human being and just talk. But don't talk too quietly and don't talk too loudly. So be humble but yet firm. Don't play with your paperwork. Don't play with pens. Don't shuffle paper. These things annoy the court. And more importantly, a point that you have made or you want to put across may be missed because you were rocking in your seat or head-butting the table, as some may do in high irritation. Don't do it. Try and sit or stand relatively still. Relatively still. Don't walk around and pace in court. It's not impressive. The judge has to watch you moving there and back. They're interested in listening to you and writing notes. They don't want to have the extra additional issue to wonder where you are wandering. So stay in your place and don't move around. Some judges like you to sit down and some judges ask you to stand up, and different courts do different things. On the whole, in the High Court you stand up. In front of masters of the Supreme Court you generally sit down, although in some courts in the Queen's Bench Division you'd stand up. In a county court before a district judge, on the whole you would sit down. In front of a circuit judge in the county court you would generally stand up. In a magistrate's court you would generally stand up. So learn what you're meant to do, and that's where the court usher or the court clerk comes in handy. Ask before you walk in, what do I call the judge? Don't call the judge the wrong name. On the other hand, court judges will tell you very happily they've been called everything under the sun, and as a litigant person you'll probably get away with just about anything, but try and be polite. But on the whole, there's pecking orders and certain titles that you have to give to people. So learn what they are before you walk into court. Make eye contact with the judge, but don't eyeball the judge. Don't stare the judge out. That's bad. On the other hand, you want to have eye contact with the judge, and you want to see whether the judge is with you or against you. And on the whole, you'll be watching the judge's body language as much as they'll be watching your body language. So you have to learn how judges are thinking. It's not always obvious. Some judges are very, very open-minded. On the whole, they are open-minded, will make their decisions at the end, even if they're asking you questions that make you feel that all is lost. They might just be playing devil's advocate. So don't count your chickens. Don't come to a conclusion that the judge has gone one way or another. Just be open-minded and present your case with an element of conviction, but with respect. There's an angle, amazingly, that you should stand when giving advocacy, and that angle is 84.5 degrees. So it's not up here, because that might be a little bit haughtiness. It's not down here, because it's a bit too humble. It's somewhere about there. It's about there, 84.5 degrees. There are a few books that I would recommend to you. One is called The Devil's Advocate by Morley. It's a very good book. It's a very short book. That's why it's a very good book. And it's got good points in it, and it's quite short. And he says, a respected advocate is a credible advocate. A credible advocate is a persuasive advocate. And a shouting out advocate is useless. So what you want to do is to keep it simple. You need to tell a story and give that story interest by varying your tone and the volume and the pitch and the pace with adequate pauses. But be brief in delivery. The judge doesn't necessarily want to know where you were born, where you came from, what you had for breakfast. Try and make it relevant, the points, to your actual case. And sometimes, as I said, it can be very hard as a litigant person. You can't always be objective, you're more likely to be subjective. But it's worth going to a lawyer or to someone else, even a friend, and saying, listen, am I saying too much? Have I put too much in? Because remember, you've only got a certain amount of time in court to put over your case, and you have to check the time estimates. The court's going to want to have time to read. They're going to want to have time to listen to you, to listen to the other side, to listen to any points in reply. Then the court's going to want to give judgment. And the court's going to want to try and do that on the same day, if they can. So it's important to really keep that, tell the story, but keep it brief. Talk in threes. Everything has a beginning, a middle and an end. And you should say your points in that way. It should be reasonable, plainly delivered and logical. Simple, softly delivered, with common sense. Talk in threes. People like threes. They really do. So another thing to do is to watch the judge's pen. If the judge is not writing anything at all, that's not a good sign. Not a good sign at all. Unless you're perhaps Master Bragg, who doesn't necessarily make any notes at all and will sit there for days and then give a perfect delivery without any notes whatsoever, having recorded every fact. But very few judges are like that. So you want to watch the pen. Normally, when a judge is not writing, it means he's not interested, and the point that you're making is not relevant to what he or she is thinking or looking at. Of course, when the judge is writing, you want to go as slowly or as fast as the pen, almost as if you're dictating to the judge what you're saying. So watch that pen. It's a very important indicator. Again, a staring judge is a bad thing. That judge just staring at you like this is not good. A judge doing this as you're saying the points and almost nodding with you is known as a guggling judge. Guggling judges are good. It means that they're taking on board what you're saying and they're listening. It doesn't mean that they're accepting what you say, but they're at least taking the points in to consider. And presentation, the way you present a case in court, is normally as this. You state the facts, then you state the case law and the statute, and then you apply those facts to the case law and the statutes. And that's how you should look at a case. There's a way of presenting. So there's a few don'ts and a few do's. Don't be arrogant. Don't be a diva. Don't upset the judge. don't upset the court staff, don't become over emotional, and don't be intense. But above anything, don't lose your temper. Very much so when you're a litigant in person and you're up against a barrister or a solicitor advocate on the other side. They will be vastly more experienced than you in delivering a case and how to say something and how to put the points. The judge will know that you're a litigant in person because firstly you'll tell them, secondly because you have to fill in a form saying that you're a litigant in person if you're not represented, and the judges generally have had to read volumes of books on how to deal with and talk to and treat a litigant in person, and on the whole they have to be patient and they have to place and weigh up on the scales who is more able to advocate and who isn't. So if you're struggling, the judge may ask a question and say, the way I've read this, this is what you seem to be saying. Now that judge is saying that to assist you. The judge isn't against you. Please don't take that position, because if you do and say, I never said that, that's not what I said, you have the judge's backup. So the judge was trying to assist you. So one way to answer a judge when the judge says that is to say, and if you think you disagree with the judge, you would say perhaps, my lord, if you were in the High Court, you would say, my lord, I understand how you've read it that way, but that's not what I meant. What I meant was, and you will say what you meant. So don't be confrontational with that judge, because the judges aren't there to be confrontational with you. They're there to get to the nub of the heart of the matter and to make a decision. So the do's: do be polite, do be respectful, do be calm, do relax, and do get into a rhythm as to how you say things. There's a patter, a way of speaking, and the judge, it will be easier on the ear if you talk in that way rather than talk in a disjointed way. The point about relaxing is a bigger point than I've made here. The point about relaxing is this: if you are intense and talking intensely to a judge, the judge will also be intense. Will try not to be, but after a while it will be infectious. In the same way that you can be infectious in your enthusiasm, you can be infectious in depression and stress, and everyone becomes stressed out, and it makes not a good day in court. So try and sit back. I know it's easier to say than it's done, but look, if you know your case and you believe in your case, you can say the case as calmly as you could when you were shouting. It doesn't help the judge to hear any better. In terms of reading material, I would suggest 3 books. The one is Ian Morley, The Devil's Advocate, I just mentioned before, Richard Ducan on the art of advocacy, and Francis Wellman, The Art of Cross-Examination. These are excellent books and I would highly commend you to read those. If you have any questions that arise from watching this, please do not hesitate to contact the litigants in persons, or otherwise contact myself. I hope that's of assistance to you, and I wish you well.